welcome you to another episode of Conversations at Foothills by Isra. Recent conflicts, we have seen there is a disregard of international law.
There's a difference of opinion amongst the entire JAG branch within the US administration as well. A lot of military personnel disagree with this approach, and perhaps that's one of the reasons why they were sidelined.
We have seen what happened in Strait of Hormuz. So there is a law of the seas as well. The powers in the conflict, they do not care about the laws anymore.
Choosing targets of civilian infrastructure like airports and refineries and all that was in clear violation of international law.
That's the biggest question mark on international law.
The chartered when the victor would extract money from the loser for the expense of war. Iraq was made to pay $52 billion to everyone who was affected by war.
Is collective security, is the notion of collective security also over and every country is to defend for itself?
They say this is our strategic interest of the primary importance. We don't care now about the law and the rules.
Why is there no concern of great powers or whatever is happening in Gaza?
There's a religious narrative which dominates and overrides Israeli policies based on which they satisfy themselves that killing children of another religion, killing women, children doesn't matter.
How do you see the future of legal world order?
We are poised for a very interesting role if we play our cards well. From a legal perspective, strategically we are doing generally fine.
Hello and Assalamu alaikum. My name is Rehman Azher and I welcome you to another episode of Conversations at Foothills by Isra. Today we are going to discuss relevance of international law in transforming global order. And we have a very eminent lawyer, former caretaker law minister and international law expert, Mr. Ahmer Bilal Soofi Saab with us. Soofi Saab, thank you so much for your time.
Pleasure is mine.
Soofi Saab, I'll start with a very basic question, and this concerns international law in general. Is international law in a sort of systematic crisis?
Well, yes, it is in crisis. That goes without saying. But let me say that the norm of international law is intact. It is the institutions which were entrusted with the competence to enforce international law that have been partially paralyzed, particularly United Nations. And within United Nations, the Security Council in particular, because it has the mandate to pass Chapter 7 enforcement resolutions and directions, which it can't, because one of the P5 members or two P5 members have different approach towards that. So the mere fact that the enforcement aspect of international law is under strain does not mean that international law as a body of rules has evaporated. It exists on the statute books, it exists as conventions, and there are not many, one or two or three or four conventions we are talking here.
Right.
We are talking of thousands and perhaps millions of bilateral and multilateral instruments which continue to exist. There may be a violation of one or two of them at the moment, but the remaining regulatory framework, which is again the body of international law, is existing.
But isn't enforcement and mechanism is also part of the legal paradigm that should exist with international law?
Certainly it is, and the idea of efficacy of international law is linked to its enforcement capabilities. Now, certain enforcement are done by regional bodies. Certain segments of international relations and issues are regulated by specialized bodies, like International Civil Aviation Organization, for example, regulates the use of airspace, which is a specialized area. Now, the body which is regulating it is intact. It continues to issue appropriate regulatory frameworks. The International Maritime Organization, which regulates the lanes and so on, is still intact. The laws relating to movement of containers, liability of ships, insurances, transactions are intact. And of course, when you look at international laws which are being violated or they have been disregarded, everyone is using the same norm to identify default on the part of the state which is defaulting or disregarding it. So the measure, the norm, is actually getting even more strengthened by virtue of the fact that it is a reference point of making a determination of its violation.
Right, but in recent conflicts, we have seen that great powers, there is a disregard of international law. For example, we have seen that in the recent Iran-US conflict as well. And the perception is that these powers do not care about international law at all. Why is that?
There is a power paradigm, of course. There is a realpolitik. I mean, when after Second World War, certain group of states decided to create a global legal framework which suits their political interest. And within that framework, yes, developing countries and developed countries were given due regard for participation, lawmaking, convention making through UN General Assembly, other frameworks. Of course, this was with the intent that this will be enhancing their strategic goals. But when they found out that some other countries are taking more advantage of the same set of rules, like China, for example, made full use of WTO framework to roll out belt and initiatives of CPAC and so on and so forth all over Africa and elsewhere, then they realized that this order which they had themselves created, erected, and supported is becoming counterproductive. Now, again, that's a view of perhaps one power, which is United States right now.
Right.
And within the US, there's a divided view. Some say, in fact, most of the voices are continuously saying that is wrong what we are doing. And if you recall, there are about 100 international lawyers in the US who wrote a kind of a common document saying whatever the US government is doing. So this administration has a very different approach towards international law versus the remaining section of the US government and the US
But for example, if
intelligentsia.
we compare it to the invasion of Iraq back in 2003, we saw Colin Powell giving presentations in front of the UN Security Council trying to prove that Iraq has WMDs. But in case of Iran, we did not see any such presentation, or if US even cares about it. So what has changed in last 20, 23 years as far as regard for international law is concerned?
I think it's the immediate president and his close people around him who have a completely a different view, I would say complete disregard for international rules, for rules of engagement, for rules of going to war, for creating a lawful justification for going to war. Whenever you are going to any armed action,
Hmm.
you have an approach. You normally use that approach to say there's a law or regulation which will justify the use of force. And that justification was only through self-defense framework. And self-defense required an imminent threat. So the imminent threat evidence was nowhere to be seen. And that's what people have been saying. Even in US, American Society of International Law said that exactly. There is no evidence of an imminent threat.
All right.
So I believe that that has to be recognized.
So, but do you see more of as an administrative decision, a decision on part of current U.S. administration rather than something to do with the legal world order?
Yes, I would say so. I would say this disruption is associated at the moment with a very select group of people who are administering right now the US policies. For example, you have the Secretary of State, Secretary of War. Now, the Secretary of War was initially Secretary of Defense. The department's name was Secretary Department of Defense. Now, Department of Defense was the name used because in 1945, when we had the UN Charter, before that it was called Department of War. But when the UN Charter came into existence, you could only use force in self-defense. So the US government, in regard to the UN Charter formulations, said we will now call it Department of Defense, which means US will use force only in self-defense anywhere in the world. But when he arrives, he says, I'm going to rechange it,
All right.
Department of War. So the messaging is clear. We will use force
But these
now by this
law,
administration.
but
And if I may,
yeah.
there's a difference of opinion amongst the entire JAG branch within the US administration as well. A lot of military personnel disagree with this approach, and perhaps that's one of the reasons why they were sidelined.
But the laws of the war generally, but it is a perception. For example, 2026 Geneva Academy study, it suggested that they are becoming obsolete due to widespread violations. We have seen that in conflict of Russia, Ukraine. We have seen that in Gaza as well, and we have seen even in this conflict as well that a ceasefire happens, but then the ceasefires are being violated again and again, and there is less regard for any such agreement. Do you agree with that?
No, I don't entirely agree with the finding of the My view is that the laws of war continue to exist and they will continue to exist for multiple reasons. They did not start with Geneva
So
Convention.
the rule book is still there.
The rule book is there, and because it's backed up by civilizational maturity history. All civilizations of the world came to this realization they can't go on endlessly fighting with each other. As human race, you have to excel together with cooperation, with economic integration. So therefore, even if you have to fight, whether in self-defense, whether in humanitarian intervention, there should be some rules of engagement.
All right.
That was called the law regulating the conflict. So for that, you have to be distinction principle, selective targeting, military targeting. Now, as I said, these rule books are part of the jurisprudence of each and every P5 country, each and every country of the world, and that's what the armies follow. Not only do they have internal mechanisms of assessments, like even court-martial proceedings, they also have international frameworks, like the ICC, International Criminal Court Framework, and so which basically is saying that while the implementation of the rules may suffer, but the rules are intact, and there's a complete consensus on that. Because why? All three religions, any Indian religion, have complete consensus on the rules of the combat,
All right.
which have been then translated into English language or whatever relevant UN language in Geneva Conventions and Hague jurisprudence. So they are not vanishing. They remain the standard to measure, and they will continue to be so.
Coming back to the conflicts, for example, we have seen what happened in Strait of Hormuz. So there is a law of the seas as well. There are multiple conventions. There is generally an agreement, but we have seen in terms of blockades and attacks on ships, it appears that the powers in the conflict, they do not care about the laws anymore. And even if a country is a neutral country, or it's a party to the conflict, so there is no distinction. So why do you think this is happening?
Again, as I said, I mean, it started off, unfortunately, with the way US perceived target selection in Iran.
Hmm.
Now, their choosing of targeting, let's say, a girls' school, whether inadvertently or deliberately, their choice to target the political leadership, the choice to target other infrastructure was a violation of international humanitarian law, or IHL. In reaction, Iran then decided to attack civilian infrastructure as well as the military bases in the Gulf. Now, to the extent of selecting the bases as targets, to me that was considerably lawful. Why? Because they were being used against Iran. But then choosing targets of civilian infrastructure like airports and refineries and all that was in clear violation of international law by Iran again. And as I said, that's what the measuring tape is. Everyone is saying they have violated international law.
Right.
Based on these norms that we are saying, do they exist? Well, they do exist. And they continue to be the standards on which these conducts are being measured and ascertained how lawful or unlawful they are. And therefore, when you're making these choices of target selection in a conflict which is also controversial in terms of why did it start to begin with, but once it has started, again, the applicable framework is there.
But what about compliance and enforcement?
That
Who
remains
is
an
going
issue.
to do it?
That remains the issue. You have to be creative about compliance.
Because that's the biggest question mark on international law, that the documents are there, the rule book is there, but what's the use if there is no enforcement or there is no compliance?
There are two ways. One is a conventional enforcement, which is you make UN Security Council again robustly active.
No.
Or if there's a veto issue, then maybe perhaps UN General Assembly can create a forum for that. If that doesn't work, then possibly regional arrangements could come up. And the countries which are associated with this, they can come together for some sort of an arrangement in which a norm could be enforced voluntarily by the applicable countries vis-a-vis each other. And then again, a creative solution could be creating a claim framework, making war sound costly to anyone who inflicts it. And that way, and that's been done.
But isn't always the victor that decides that?
That was pre-charter framework. The charter, when the victor would extract money from the loser for the expense of war, from Germany, for
That has
example.
happened in
That has
history.
happened. But after the UN charter, it's the aggressor who is being held liable to pay. That's been the customary norm. If you recall, in 19, we had the Vietnam. At that point in time, we did not have a compensation framework followed.
Right.
But in Nicaragua, ICJ said US has to pay. So that was the first precedent. The second important precedent from relevance of the Gulf War is the Kuwait attack by Iraq. And then it was said, and the compensation tribunal was set up. Iraq was made to pay $52 billion to everyone who was affected by war, whether Kuwait or elsewhere, including individuals. Individuals were invited to file claim. It took 22 years. It ended in 2022. The same year, ICJ inflicted a war reparation order between two African countries. So I think if we are able to, and in Ukraine, there is now a register being maintained by European countries, a register of claims. They've created a legal framework saying anyone who is disrupted, affected by Russian aggression should register his claims.
But it's very
So why can't we
interesting.
create something right now?
Very interesting you mentioned Ukraine, because international law also, it has a concept of collective security. It is based on that order of collective security. But in Ukraine, we saw UN being in a sort of paralysis and failing to stop any conflict taking place. So is collective security, is the notion of collective security also over, and every country is to defend for itself?
No, I think collective security continues. Let me explain Ukraine a little bit. I think there are certain guidelines for every P5 country where they stop worrying about international law. They say this is our strategic interest of the primary importance. We don't care now about the law and the rules. When the threat is very close, in the close proximity, territorial proximity of them. So if there was Cuba crisis, Americans said we can think of using the nuclear. We forget about everything, a rule or NPT and so on. If there's a threat right next to us.
Right.
So in case of South China Sea, China also said that this is too close to us. We believe this is ours, so it's our red line, and we disregard any judgment of the court which awards this to Philippines or elsewhere. And in Ukraine again, the same thing is happening. Russia says you are crossing my red line. NATO is coming and sitting next to me. I don't care about. So I think those red lines cases apart, while those strategic interests are challenged, I think the rules will be sidelined because that is a necessity of the statecraft. But short of that, the rules-based order continues. But now we also have.
But is it something which is temporary, that the rules are being sidelined, or do you think it is permanent? Because
No, I think
you said the basic understanding is the law is based on customs and traditions or whatever is taking place.
yes, I said the law that exists today, the basic norms of non-attacking others, giving respect to human rights and all that, are based on civilizational maturity, and there's a religious backup to it.
Sorry, let me just reframe my question. Is the rule book being rewritten again?
I think not entirely. I think the rule book stays the same. The enforcement framework may switch from global to regional level. That could be one way of looking at it. The other could be you could identify if there are a group of 57 Muslim countries, for example, and you identify the common international treaties that each has with the other, you will come across a stack of legal commitments that all 57 Muslim countries had with each other. So to the extent of those common commitments, they can say, okay, fine, we will mutually agree how to enforce them.
Right. So it'll be blocks deciding
Possibly.
that they want to enforce a certain set of rules among themselves.
Because one block like Shanghai Corporation hasn't taken off to a level where it ought to. So therefore, I think the regional blocks and whatever we are discussing and the way things are developing in our own region, I think we have an opening for a legal leadership of developing a narrative, emphasizing the rule of law framework, and that will give any country enormous credibility when it stands up and says, well, me as a country would like to stand up for the rule book, even if it is being attacked or even it has been dented for a while.
Let's say wars are complicated. The rules of the law, laws of the war are, relative. But international humanitarian law, this is something on which everybody agrees. But what we saw in Gaza Gaza is very different story. An utter disregard of international humanitarian law, choice of targets. I mean, from everything that goes against the rule book. What happened in Gaza? Why is there no concern of great powers for whatever is happening in Gaza?
Of course, there is a strategic and a state, I would say, real politic behind it, but keeping that side, I think the countries who say why didn't something happen are to be held responsible for that, because every country in the world, more or less, is a party to the Genocide Convention.
Right.
Genocide Convention's Article 1 is very categorical. It says states parties to the convention have a duty to prevent genocide. It's a duty. Now, use coercive measures, non coercive measures, whatever, to prevent. No country came forward taking suitable measures. I'm not saying attack or announce attack, but there are a lot of other measures that could possibly be taken to deter the genocide framework. So I think let's not pin the responsibility on one international organization and create that as an alibi for not doing ourselves anything. I think every country had a role to play to make efforts to prevent, which we chose not to.
Right, but my question was that international humanitarian law is something on which everybody agrees. I mean, the rule book has not changed at
Yeah,
all,
yeah.
and it's probably going to be the same. I mean, there's no indication. Then why it seems that the legal order, the world cares. I mean, we have seen protests happening in the world, the public cares.
I think
But
I pick your question.
legally, Israel is not being held responsible.
I think if you look at the rule book within Israel on the law of conflict and the rule book of US within the law of conflict, you find interesting situation. The US has a manual of war. DoD has a manual about 1,000 pages. It literally mirror images the Geneva Convention. So the rule book is very clear. And there are over 4 to 5,000 JAG branch lawyers in addition to CENTCOM 500 plus lawyers who do the target selection verifications, who vet the targets from a legal IHL point of view. So put them aside. In Israel, there's a religious framework which dominates. We are a superior race. To those who are here, they don't have the right to exist. It's completely coming from a religious direction. And that's the most dangerous part. There's a religious narratives which dominates and overrides Israeli policies, based on which they satisfy themselves that killing children of another religion, killing women, children, doesn't matter. We are being a superior race, or whatever doctrine that they develop, it entitles us. So the paradigm there is completely religion based, something that we have with our neighbor.
So we've discussed war, we have discussed humanitarian law, but there's another part of international law that concerns us. That is agreements like Indus Water Treaty. It appears that India at will can get out of Indus Water Treaty without any repercussions. Uh, is the world just going to let India get away with this, or do you think things will be different?
If I could peg my answer to your repercussions part, which was
Right.
initial part of the question, can India get out without repercussions? No, it is not. The repercussions are now becoming more and more pronounced against India. That is why India is in isolation. That is why the Indians are trying to struggle. Why are we isolated? We were the friends with Trump and everybody. Why is everybody sidelining us? Simply because the conduct is of a highly irresponsible state. A state develops credibility globally when it acts in a responsible fashion, when it chooses to honor its commitments. And when someone asks, for example, the money, returns it. When someone says you have to follow a legal framework, it follows that. When it tries to fulfill a mediation framework, which is the UN Charter framework, settlement of disputes framework. Now, that's a responsible
And you
behavior of a
think
state.
that is the cost which India is
Is
paying?
pain of being isolated, of no one is talking to them. And they are also in a very panic mode. If you look at the journalism, why is Pakistan? Because Pakistan is acting in a far more responsible fashion under international law as compared to India, which is sponsoring assassination, campaigns in Canada, in US, and suspending a treaty that no one can imagine is being suspended. So I believe that's the cost. When you move away from the norm, you have to incur a cost. Your allies begin to withdraw. They begin to sense you are no longer a dependable entity to deal with, and that's the cost that you pay.
And do you think other powers might take lead, going back to United States? uh, 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 of what US is doing in case of Iran, in case of Venezuela, and they might follow the same path? Or do you think that somewhere they are going to stick to the rule book that's already there?
I think they are already sticking to the rule book. They're not only sticking in terms of action, they're also saying so. They are condemning. Each condemnation is adding a value to that rule book again. Each condemnation from Russia, from China, from Uzbekistan, from Sudan, from UK, from Canada, what is it? It is strengthening that rule book. So let's not be disappointed with what's happening to international law. I see, as I said, a legal leadership role. If you are able to carve out that as a responsible state, you want to adhere to the rule book, and this is the rule book, this is what we say, this is how we want Turkey to behave, this is how we want Iran to behave, this is how we want Saudi Arabia to behave, UAE to behave, Kuwait to behave in terms of this rule book, you are beginning to take a leadership role yourself. You may not be powerful enough, you may not be economically as powerful,
Right.
but you develop that legal narrative strength that takes you forward as someone who's mirror imaging that. And then if you're tied up with your own religion, which is a common ethos of 57 countries, suddenly the momentum is unstoppable.
Well, but there are two ways. Like, for example, everybody starts following or everybody starts fending for itself. I mean, citing the example that, look, the US did this, so we are not bound by that because US apparently is a sort of guarantor of the world legal order as well. Or everybody goes like, no, we are sticking to the rule book. This is the law, and we're going to follow that no matter, even if we have to pay the price. So, I mean, as someone who realistically look at the situation, most of the countries would be like, if there is no regard for international law, then why should we do that?
The practitioner side is completely different. I mean, as I said, international law is divided between public international law and private international law. You and people generally are concerned about violation of only one treaty, which is the Charter Article 24, which has been violated all over. But there are many other treaties. So my optimism rests on the that rule book, which is very voluminous in terms of obligations. I see when you are diverting trucks into Iran through Pakistan, what are you doing it through? TIR Coordinate Convention framework. That's enabling environment which is giving you. But if you're saying that 12 nautical miles is safe, or you're saying interdiction principles are incorrect, and you will have to pay for frivolous interdiction, there's a rule book which exists which says so. So I believe the rule books are there. The implementing mechanisms may be suffering at this point in time, but sooner than later, you will see accountability beginning to come up within the US jurisdiction and elsewhere in the world as
So,
well.
what do you think is the way forward for Pakistan? Because we are close to what's happening in Strait of Hormuz. We have a neighbor that does not believe in respecting boundaries. And by the way, they also have a concept of Akhand Bharat as well. And then we have powers to be where uh, we are on our own. We have to defend our security, territorial integrity as well from the attacks taking place from Afghanistan. So, as a middle power, where do we stand? Do we cooperate with other countries, like you said, and be a part of any bloc? Or do we say, no, we are sticking to what's the international legal paradigm and we are going to stay within that framework?
We can play both the roles. There's no conflict. If you want to go for a global approach or the regional approach, both can coexist. There is a threat, and that threat is becoming, that is going to force friends and allies around Pakistan. Two common threats. On this side, we have Akhand Bharat threat, which is threatening 4 or 5 neighboring countries of India,
Subcontinent.
subcontinent. Now, they are the likely allies of Pakistan based on that threat. On the other side, in the Middle East, you have Israel, which wants to have a greater Israel and against gobble up about 5, 6 countries. Those countries could be again allies of Pakistan, or they could be allies amongst themselves for that matter. And that's where the leadership role lies, in my view, that how you help navigate these countries which are likely effectees of two extreme doctrines in the region of subcontinent and also in the Middle Eastern region. And that's where I see a new possibility where Pakistan's significance will rise in the future.
Right. And do you think Pakistan should continue with following the legal order as it
Absolutely,
exists now.
absolutely. That's going to be, that is already one of the salient features of Pakistan's standing, and it should continue to be.
And how do you see the future of legal world order? Do you see any changes coming, or do you believe that right now is a time of madness, and it'll all come back to sanity in the future?
I think it will come back to sanity gradually, for the simple reason that this is very temporary hike, an excitement which has grown. But I trust the civilizations of China. I trust the civilization norms of Russian people. I trust the civilization norms of people in Egypt, in Europe, in US, their religions, and I believe they all believe that we should coexist. Now, if there are some irresponsible people who have stepped in, everyone is upset because of that. You can see the reaction from the Europe, and you can see the reaction from here. So let's not be swept, and let's not be too negative in terms of being pessimist about it. I believe we are poised for a very interesting role if we play our cards well. From a legal perspective, strategically, we are doing generally fine.
Right. Amir Bilal Soofi sahab, thank you so much for your time. It was lovely talking to you and for you listening to your insights on international law. I mean, whether you are a realist or you're an idealist, I think one thing that we can all agree on is that whatever the law would be, the international law would be there, and we'll have to follow some sort of rule book. Everybody has to follow some sort of rule book, even in the future as well. With this, we come to the conclusion. Thank you very much.